Good afternoon, Commissioner. I would like to open this week of hearing by acknowledging that the City of Hamilton is situated upon the traditional territories of the Erie, Neutral, Huron-Wendat, Haudenosaunee, and Mississaugas. This land is covered by the Dish with One Spoon Wampum Belt Covenant, which was an agreement between the Haudenosaunee and the Anishinaabeg to share and care for the resources around the Great Lakes. We further acknowledge that the land on which Hamilton sits is covered by the Between the Lakes Purchase 1792 between the Crown and the Mississaugas of the Credit First Nation. Many of the council appearing on this hearing today are in Toronto, which is the traditional land of the Huron-Wendat, the Seneca, and most recently, the Mississaugas of the Credit River. Today, this meeting place is still home to many Indigenous people from across Turtle Island, and we are grateful to have the opportunity to work on this land. Commissioner, before we start, just to give you an overview of today's proceedings, we have Kevin Bentley here to testify as our witness this afternoon. And following Mr. Bentley's testimony, there will be brief oral submissions on a motion brought by the auditor, the city auditor.
Okay, thank you.
And if we could have the court reporter affirm Mr. Bentley, please.
Would you raise your right hand, please? Do you affirm the evidence you are about to give in this matter will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Good afternoon, Mr. Bentley.
Good afternoon.
I'm going to start this afternoon with some questions about your educational and professional background and your employment history. So I understand that you were employed by the Ministry of Transportation from around 1986 until your retirement in June 2019. Is that correct?
That is correct.
And since you retired in June 2019, have you been fully retired or have you been employed in other capacities?
I have been employed on a part-time basis with an engineering consultant, Dillon Consulting in London.
Are you still employed on a part-time basis?
I am.
In terms of your educational background, can you tell us a bit about that? Where did you attend university?
I attended the University of McMaster University in Hamilton, graduating in 1986 in civil engineering and business management.
Were you a professional engineer, a licensed professional engineer in Ontario?
I am and remain as a licensed professional engineer in Ontario.
And when you joined the MTO in 1986, was that straight out of McMaster or were you employed elsewhere before?
No, straight out of McMaster.
And we don't need to cover everything between 1986 until when you retired in 2019, but just to give us a little bit of an overview about some of your roles over time. I understand that from around April 2002 until December 2012, you were the manager of engineering in the West region. Is that correct?
That is correct.
And where is the West region? Sort of what area does
So
that cover?
it's based out of London, Ontario, and stretches from Windsor to Guelph, Cambridge, up to Tobermory. So basically the southwestern area of Ontario.
And am I correct that at some point between sort of when you held that role, manager of engineering, you also at some point in time held the role of regional director of the West region, perhaps in an acting capacity?
That is correct.
And when was that?
So that was two different time periods, if I recall, in around 2009 and then again in early 2013.
So both times that you held that role is in an acting capacity?
That is correct.
And I understand that you were the director of maintenance from July, in and around July 2013 to October 2016. Is that correct?
That is correct.
And was that position in West region or was it in a different sort of branch of the MTO?
So that was a corporate role. So that was looking after the maintenance of the provincial highway system for all of Ontario. So it's based out of St. Catharines, where the corporate office of MTO is.
Thank you. And your position at the time when you retired from the MTO in June 2019 was chief engineer. Is that correct?
That is correct.
When did you start as chief engineer?
So in 2017 until 2019.
And that was the position that you held at the time you retired?
That is correct.
What were your roles and responsibilities as chief engineer?
So roles and responsibilities. So I had oversight on the design, planning, design, engineering, construction, asset management of the provincial highway system for the province of Ontario. So under my leadership, there were directors who managed each of the areas, including construction, highway standards, investment strategies, and maintenance.
And in terms of sort of how you would characterize that role, was it more technical or policy related, or was it sort of a mix of both?
I would say it was a mix of both. Certainly, I would describe, having to have a knowledge across all of those disciplines, being planning, engineering, design, and construction, and maintenance, but then having specific experts in each of those areas that were part of my branch.
Who did you report to in that role?
So I reported to the deputy minister.
Do you remember who it was, say, early 2019?
Stephen Rhodes.
Who or which divisions within the MTO reported to you, sort of directly, let's say?
So that was the Provincial Highways Management Division. And then what I was referring to was branches that reported to me. So Highway Standards Branch, as an example, was one of the branches that reported to me.
And Highway Standards Branch, that's the branch that what was at the time the MIRO office, the Materials Engineering Research Office, was in?
That is correct. So MIRO was part of the Highway Standards Branch.
Okay. And what was the reporting relationship between you and the manager of MIRO?
So it was an indirect reporting relationship. So the manager of MIRO reported to the director of Highway Standards Branch, who in turn reported to me.
And as I understand it, the manager of MIRO in early mid 2019 was Becca Lane?
That is correct.
So Ms. Lane reported indirectly to you?
Correct.
Thank you. So turning now to February 2019, Registrar, if we could call up overview document 10A at images 99 and 100. And Mr. Bentley, we're going to be calling documents up on screen, and the registrar has the capacity to call things out, enhance them, make them bigger or smaller. So please feel free to just direct us as needed if you need us to expand on something for you.
Okay, thank you.
So if you look at paragraph 244, you'll see that on February 1st, 2019, Edward Soldo at the City of Hamilton emailed you with a copy to Gord McGuire under the subject line pavement friction. And in the, so he asked, sort of gave a little intro there at the bottom of page 99, and Registrar, if we could call up the two paragraphs on page 100 at the top there. You'll see in the second and third paragraphs of Mr. Soldo's email, he wrote, "Do you have a person the city can contact regarding pavement friction testing and anticipated values for SMA pavements? Would like to see what data MTO has in this area." So at the time you received this email, February 1st, did you know Edward Soldo?
Yes, I did. Edward Soldo previously worked for the City of London when I was actually working in London for MTO. So I knew Edward for some files that we worked on together for MTO in the City of London.
And Mr. McGuire, who was copied, did you know him?
I did not know him.
At the time you received this email from Mr. Soldo on February 1st, did you have any idea why he was contacting you, or was his email sort of out of the blue that day?
It seemed to be a very routine email. I did not know why he was reaching out to me.
And we know that there were subsequent discussions, and we can see one of those emails, which I'll have some questions about there at paragraph 245. But I take it from your answer there that this was your first contact with Mr. Soldo about the issues that ultimately gave rise to this inquiry, or are subject of this inquiry. Is that correct?
That is correct.
And was this the first contact that you'd had with anybody at the City of Hamilton?
That is also correct.
Do you know why Mr. Soldo contacted you specifically?
Do I know why he contacted me specifically?
Yeah. Did you have a sense, or do you have a sense of why it was you at the MTO that he contacted at this time?
It would just be speculation on my part, other than we obviously knew each other.
Right. Through your working relationship when you were both in London.
Correct.
And so as you'll see there in paragraph 245, the next contact that we see between you and Mr. Soldo in the documents the inquiry is received is 10 days later on February 11th. And as I said, we'll have some more questions about those subsequent discussions. But am I correct that at the time you received Mr. Soldo's February 1st email, you didn't immediately respond?
That is correct. Certainly a lot of information I was dealing with every day, and it seemed to be quite routine. Basically when his question was based on who could he contact, I probably asked staff to try and figure out who the best contact would be for him to talk to.
Okay, so you didn't. I take it you didn't perceive any urgency from him based on sort of what he said in his email?
That's correct.
And I think you said you would perhaps have reached out to staff internally to see if you could identify who the best contact is. Do you recall doing that, or is that just something that you think you may have done?
That's just something that I would routinely do.
Okay. At that time, so Mr. Soldo there in the first paragraph, he mentions pavement friction testing and anticipated values for SMA pavements. At that time, what was your understanding of sort of the concepts that he was asking about?
So again, during my general knowledge of pavement friction testing and SMA pavements?
Yes, yeah.
So I guess over my career and having been involved in the design, construction, and maintenance of highways, I was certainly aware of the ministry's practices. Generally, I'm not an expert in pavement friction testing, but as awareness of, in general terms, what we did in terms of pavement friction testing. And had seen results in the past for different pavements on provincial highways, and certainly was aware of stone mastic asphalt, based on, again, being involved in projects where MTO had used stone mastic asphalt.
So you had an awareness, but for example, it wouldn't be you wouldn't be the contact that to be able to speak to these issues with Mr. Soldo. Is that fair?
That is fair.
Okay. And the inquiry has heard evidence from a number of MTO witnesses about the MTO's use of friction number 30, which isn't mentioned here, but did you have a sense of, did you have any understanding of the significance of FN 30 at this time?
I was, aware of the, ministry's testing relative to FN30, and a general guideline around what we did when it was above or below FN30.
And what was your understanding of generally what was done when it was below FN30?
So I guess some of the prior involvement with highways related to FN less than 30 was we had, kind of put those again on provincial sections, provincial highway. We would be, monitoring that friction on a basis, and also looking at other characteristics of that highway. And when I was in the region, if we had concerns about a specific section of highway, we could request friction testing if other factors thought that was something that we needed to look at.
Thank you. Just one moment. And in terms of, you mentioned earlier that you were aware sort of in general terms of what the MTO did with, in terms of pavement friction testing. Were you aware of sort of the different purposes for which the MTO would test friction?
I was aware. So as I said before, there could be, tests for specific section of highways where there could be a concern based on other factors. There was testing, on some different types of asphalt if there were concerns around the friction quality of that asphalt. And I also was aware that we did friction testing for suitability for including materials onto our designated source of materials list.
Thank you. Okay, Registrar, if we could call up HAM 28695 at image 3. Thank you. So, Mr. Bentley, you'll see down at the bottom there, there's a February 11th email from Mr. Soldo to you, and that's the same email that was at paragraph 245 that had been up on the screen earlier. But you'll see here about 10 days later, Mr. Soldo writes you again under the same subject line, pavement friction, following up on his earlier email, and says, was wondering if you could give me a call. Thanks. So between that February 1st email that we looked at and this email on the 11th, do you recall if you had any contact with Mr. Soldo, or was this the next point of contact?
It was the next point of contact.
And when I asked you earlier about the February 1st emails, as I understood your evidence was that was sort of an out of the blue email. When he emails you on February 11th, did you have any understanding about did you have any further understanding about what he was emailing you about?
In terms of the context, I would say the answer would be yes, because we were aware of the, some of the matters with respect to the Red Hill Valley Parkway, and specifically there had been some media requests and also a statement, I believe, by Andrea Horvath at the time.
Okay. And so was it through the media and the statement by Ms. Horvath that you came to first learn about some of the issues or the context surrounding Mr. Soldo's email?
That is correct.
Registrar, if we could call up MTO 38359 at images 6 and 7. And just Mr. Bentley, while we're waiting for the document to be pulled up, this will be a February 11th, 2019 statement that Ms. Horvath was issued by Ms. Horvath's office. So Registrar, if we could call out the press release on image 7. And I'll give you a moment to review, but just to summarize, this statement was issued by Ms. Horvath in relation to the Red Hill Valley Parkway and 2013 friction testing that had not been publicly released. And at the end of the second paragraph, the statement mentions friction testing performed by the Ministry of Transportation. So it says, Horvath and the official opposition are also calling for provincial Ministry of Transportation friction tests on the roadway, which were referenced in a 2015 Public Works meeting, to be released now. Those tests were conducted by the ministry shortly after the 7-kilometer parkway was completed. Is this, I take it this is the press release that you are referring to?
That is correct.
And Registrar, we can end this call out. Thank you. And Mr. Bentley, you'll see that there are some subsequent emails where the media gets in contact with staff at the MTO, and this email chain continues on for a number of pages. But suffice to say that this generated follow-up by the media to the minister's office and some internal discussions at the MTO on February 11th and 12th about how to respond to the media inquiries. And the inquiries received 2 email chains, including the one that is up on the screen, that proceeded sort of parallel to each other on February 11th and 12th in relation to the media inquiries and responses to the media. So the registrar can scroll through this if you'd like, if it would be helpful. But that's sort of a summary of what this document is. And then registrar, if we could call up MTO 38360. At image 3. And so this is the other email chain sort of happening at the same time. And you'll see down at the bottom, there's what is described by Mike Winterburn as our lines on the Red Hill Valley Parkway. And that's the evening of February 11th. And then sort of a third of the way down the page, there's an email from Tom Hermantis at 9:22 the next morning on February 12th. And you are copied on that. And for my review, that 9:22 email is the first email that you were copied on. And so do you recall receiving these emails on that day?
I recall receiving that email because it's in front of me here, but as you can appreciate, we covering all the issues across the province, we received, if not tens, if not 20s of these type of what we call issues management emails every day.
Okay.
So I cannot say that I recall receiving this email. I mean, obviously I did. I remember the issue, but in terms of receiving it at 9:22 a.m., I cannot speak to that specificity.
Okay, fair enough. So more generally, do you recall receiving emails and media inquiries in relation to the Red Hill Valley Parkway, sort of February 11th, February 12th?
I do.
And so just to sort of piece together the timeline, the email that Mr. Soldo sent you that we looked at before on February 11th, that comes into your inbox mid-afternoon, 2:24 p.m. And then there's these emails sort of that start with Andrea Horvath's statement and then proceed through the MTO internally, and this email here on February 12th. So the 9:22 a.m. email, that's the first email that we see you copied on. So do you recall if you were sort of just, even if you didn't receive an email directly, were you otherwise aware on February 11th of these issues?
I recall that I was.
Okay, and was that just sort of through the media or the grapevine through the grapevine at the MTO?
That yes, I was aware. As I recall, I was aware that people, because there's also one of my direct contacts at the time was Bob Nichols and Lisa Heaton, who were copied there below. I knew that they were working with the minister's office on this issue, so I kind of knew it was in the works, so to speak.
Okay. And Mr. Nichols, is he in communications or media relations?
Correct.
Thank you. And sort of as is clear from these documents and the other documents the inquiry received, it seems like there's sort of multiple things happening at once. There's Mr. Soldo contacting you, the press release, media inquiries, and MTO staff trying to sort of piece things together following the media inquiries. Is that sort of align with your recollection? There was lots of things happening all at the same time?
That is correct. And
just to sort of flag for you, I've tried to organize my questions sort of chronologically and in a way that makes sense, but there are quite a few emails that sort of cross over each other and overlap. So we'll be bouncing around from document to document a little bit. And if at any point you want me to go back to a document or call up multiple documents at the same time, I'm happy to do that to sort of situate you in the context.
Okay.
But staying here on this document for a moment, if you look at the bottom register, if we could call up the bottom third of the page, that perfect. Yes, thank you. So in the initial response sent by the MTO, the fourth bullet down says, MTO conducted friction testing on the pavement surface starting in 2007, only to evaluate the performance of the stone material used by the Red Hill Parkway project's aggregate supplier for use in future provincial projects. Minister Urick will be ordering the release of these test results and asking MTO officials to offer technical assistance to the City of Hamilton. So, and this was sent on February 11th. So as of February 11th, as I read this, the decision had been made to release the MTO's friction test results. Is that fair?
That is fair. So this email is from Mike Winterburn, who was in the minister's office in a communications role.
And to your knowledge, who made the decision to release the friction test results? Was that the minister?
I have no knowledge of that.
But you weren't involved in that decision?
Correct.
And in the top bullet there, it says MPP Donna Skelly and the Mayor of Hamilton have both called for a review of what happened with the Red Hill Parkway. Minister Urick has asked MTO officials to review all ministry involvement with pavement testing on the Red Hill Parkway. Do you recall the direction from the minister to have MTO officials review all ministry involvement in relation to the Red Hill?
To best of my recollection, this is the only direction we received were these draft key messages that had been sent from the minister's office.
Okay, so it was never a direct from the minister or somebody else above you. It was through these media responses that you learned of this direction?
Correct.
And broadly speaking, how would you characterize what your role or your involvement in this direction was?
I guess making sure that it did happen. So and when you had the email that it came in the next morning to Tom Hermantis, and you'll see the direction was for us to do some fact checking, I believe. You can pull that back up again, please.
Sure, Registrar, could we close this call out? So there where Mr. Hermantis says we will need to release the test results along with a reader's note explaining them. Is that what you were referring to?
Correct.
Okay, so you describe your role as sort of to make sure that MTO staff and MTO officials were reviewing the ministry's involvement and providing information as needed?
Correct.
Thank you. Registrar, can we close this document out and go back to overview document 10A at images 100 and 101? Thank you. So, Mr. Bentley, you'll see in paragraph 246, which stretches onto both pages, there's an email from Heather Evoy to Miss Lane and others at the MTO. And in the blue text there, she refers to Kevin, and she says, Kevin has edited the 3 questions. And so just sort of to situate you, this email is an excerpt from that bigger email chain that we just had up on the screen, but it's a little bit easier to see in this format because the colors show. So there where Miss Evoy says, Kevin has edited the 3 questions. I take it that Kevin is you, is that right?
That is correct.
Okay. Who is Miss Evoy?
So Miss Evoy was my executive assistant, and she was the one that primarily dealt with what we called issues management, or dealing with requests from media, or dealing with requests from our Queen's Park office.
And specifically in this context, in relation to the Red Hill Valley Parkway media inquiries and responses, what was Miss Evoy's role?
So Miss, as seen here, her role was to reach out to the, as she referenced before, to the subject matter experts, in this case Becca Lane, to gather the information and ensure accuracy of the information.
And then in terms of sort of the interplay between what she was doing and what you were doing in relation to these responses, how would you describe that?
So she would gather the information and then bring that information for me to review and to weigh in on.
And make changes or edits as necessary?
That's correct.
And is that how you would sort of describe your role in this context, is primarily to review and sign off on responses or information?
That's correct.
Okay. Okay, thank you. Registrar, if we could, we can close this call out, or this document. So turning now to picking back up on that February 11th email from Mr. Soldo and your discussions with Mr. Soldo and the City of Hamilton in February 2019. Registrar, if we could call up HAM 28727 at images 2 and 3. And before I get to my questions, just so that I don't forget, Registrar, this document will need to be marked as an exhibit. It's not in any of the overview documents. So if we could mark this as exhibit 150.
Noted. Thank you, Council.
Thank you. Okay, so Mr. Bentley, you'll see there the image on the right side is that February 11th email that we've looked at before. And above that, you'll see there's a response the next day on February 12th from you to Mr. Soldo with Miss Lane copied. And you write, Ed, as discussed, here are the 4 files for each lane for the 4-kilometer section where friction testing was completed to evaluate the stone for inclusion on the DSM list. I have CC'd Becca Lane if you have any questions about the testing. And attached to your email, as you say, were 4 PDFs, one for each lane of the Red Hill Valley Parkway, with graphs plotting the MTO's 2008 to 2014 friction test results for each lane. And do you recall sort of these discussions on February 11th and February 12th?
I do.
And you'll see on the left screen, there's an email that Mr. Soldo sent in response thanking you and asking for some additional information in relation to the graphs that you had provided. In your email to Mr. Soldo, it says, as discussed. And we know that there was a telephone call on February 12th, which we'll come to. But when you say as discussed, was that in reference to the phone call or a different discussion?
No, to the phone call.
Okay. And who was present on that call? Was it just you and Mr. Soldo, or was anybody else on the line?
I can't say for certain, but I would, based on, I'll say, my practice, I would believe that Becca Lane may have been included on that call, and perhaps Heather Evoy as well.
Okay, so for sure you and Mr. Soldo, possibly Miss Lane and Miss Evoy?
Correct.
Do you recall how the call got arranged? Did you just pick up the phone and call Mr. Soldo, which sort of appears based on his earlier email that he's just inviting you to give him a call?
That's my recollection.
Okay. So no other emails or anything between?
That is correct.
Okay. Registrar, if we could keep image 2 up and also call up image 1. Thank you. So in the evening on the 12th of February, Mr. Soldo wrote a note to file about the teleconference and the discussion with you, which he sent to himself and with a copy to Mr. McGuire and Dan McKinnon at the city. And you'll see there, we can call it up and expand it if that would be helpful for you.
That would be helpful.
Sure. So Registrar at the bottom, sorry, it's actually it's the lower note to file. Yeah. And that continues on to the other page. Thank you, Registrar. So Mr. Bentley, I'll give you a moment to just review these notes of the call, and you can let me know when you're finished.
Okay.
Looking at these notes, do they appear to be an accurate reflection of what was discussed on the call?
They do.
Are there any notes that you disagree with or think are perhaps an incorrect or incomplete reflection of the call?
On that day, there are, I mean, I guess we'll speak to February the 13th, where there was a correction in information about the 2007 testing versus the 2008-14 testing. But as of on February 12th, they are an accurate reflection of our discussion, and based on my recollection of that.
Okay, right. So to the extent that there might be something that is an incorrect piece of information that then gets corrected down the line, that is reflected here. That's not necessarily, that's a reflection. The incorrectness in this note is perhaps just a
as of February 12th, correct.
Correct. Okay, thank you. And did you take any notes on this call?
I did not.
And I think you may have answered this, but just to confirm, the February 12th teleconference with Mr. Soldo, was that your first substantive discussion with him?
That is correct.
And I can take you to some of specifically to some of Mr. Soldo's notes, but sort of generally, can you tell us what you recall about that discussion?
I recall that part of that discussion, and that, again, as I said, I don't recall whether or not Becca was part of that call, but I certainly had some discussions and had reviewed the information before having the conversation with Mr. Soldo. But the conversations at that time were that the friction testing, as it said here, was done to look at a particular stone for use on our designated on our DSM list. As I say here, as stated here, it was a 4-kilometer section only. It speaks to the data, and then as I said, then I sent the data over to him for him to look at himself. After we had a conversation, again, because it was based on the MTO testing method, so it's very specific to the MTO testing method. So again, we had, for him to understand, to put some context to him around the data before I sent it to him. And then I guess the final point there is that, as you saw I'll say the direction from the minister's office, we offered our assistance and specifically, again, as I said before, Becca Lane was more of a subject matter expert in the area of friction testing. So again, the reference to her as the manager of materials and engineering research office available to help him interpret the data, because that was something obviously she was much more qualified to speak to.
Right. Okay. And I think that's consistent with the email that you had sent to Mr. Soldo earlier that night, where you copied Miss Lane and offered her assistance. In terms of sort of the nature of the conversation, would you say it was sort of a back and forth between Mr. Soldo and yourself, or was it really you providing information and context, him perhaps asking you some questions, but sort of how would you describe that?
As I recall, it was more of an information sharing call. Again, given we were trying to go back and find information from, dating back 12 years prior, 2007, 2008, trying to find that information, which we'd spent, February 11th and 12th looking for it, verifying it. And then again, but it was primarily more information sharing, as I recall, on my part, than Mr. Soldo asking questions.
How would you describe the sort of tone or demeanor of Mr. Soldo on that call, if you can recall?
I don't recall, but certainly nothing jumps out at me that there was anything out of just an information sharing type tone.
Okay. And in terms of Mr. Soldo's knowledge or familiarity with what's reflected here on the notes, how would you describe that in terms of his awareness or his knowledge of the concepts and topics we're discussing?
I would say that his awareness was much less than I would say compared to myself, and obviously was certainly not did not, again, that's why part of this, the reason for the call was he was certainly not knowledgeable. I don't think that certainly was his area of expertise, was around pavements and friction testing and so forth. So the call really before sending the data was for him to provide him some context and some understanding around the data.
Okay. And I think you said you may have spoken with Becca or Miss Lane. Do you recall that? Was that something that you did in preparation for this call?
I can't say for certain, but I do recall having a conversation and reviewing those Excel documents with Becca. And I would certainly, based on my practice, would have had that call before I would certainly want to be knowledgeable about the data before I had a conversation with someone else about it.
Right. Okay. And in terms of the information here, would this have been new information for you that you would have learned between February 11th and February 12th? It wasn't information that you knew prior to speaking with Miss Lane or anybody else at the ministry?
That is correct. I would have no reason to be aware that MTO had done friction testing on the RHVP. I certainly, and I would not have been aware I had no involvement in that time frame with the DSM list. No involvement at all with Materials and Engineering Relations Office, as I said previously. At that time, I was working in a regional office, London.
In the sort of the first paragraph of that second call out there, it says, the second sentence says, run for 7 years, although some years the testing was not undertaken. At the time of the call, did Mr. Soldo already know that the MTO had done friction testing for a number of years, or was this new information for him that you were conveying?
I recall that this was new information for Mr. Soldo.
Do you recall what his reaction was to providing that information?
Again, my recollection is there was no, I'll say, extraordinary reaction.
Okay. And
nothing
then,
out of the ordinary.
okay, thank you. 2 paragraphs below, it says, I asked for the data to be sent over, received shortly after the call by email. So I take it those are the PDF documents that you sent to him, or the 4 files that you sent to him subsequent to your call?
That's correct.
And at that time, prior to your call, you hadn't sent any documents or friction test data to the city?
That's correct.
In that same paragraph there, it says, Kevin Bentley identified that the same methodology may not have been used in assessing the end friction value in the city testing. Do you know what that's in reference to?
So by that point, I was aware that the city had done some testing as well. I think it was, if I recall, I think people refer to it as a trade wind testing. Mm-hmm. And that was not done using the same testing methodology. I'd been advised by Becca, that it was a different method of testing than the brake trailer that MTO used. Okay.
So had you read the trade wind report, or was this information that was conveyed to you through Ms. Lane?
I just was aware that the city had done testing, but I had not read the report or seen the report.
And would this have been new information that you were conveying to Mr. Soldo as well?
Which the methodology was different?
Yes.
I don't recall that, but I just wanted him to be aware that the test results that they had and the test results from MTO were not directly comparable.
Okay. And then the next sentence there says, for comparison, the specification for Highway 407 includes a value of 30 where more investigation is required. The reference to FN 30 and the 407, that was information that you conveyed to Mr. Soldo?
Yes, based on providing context. I'm not sure about, I don't think I would have used the word investigation, but perhaps monitoring would have been probably the word that I would have used.
And in terms of the context that you were looking to provide to him, do you recall why you wanted to provide him that context, or sort of for what purpose you were sharing this information about the 407?
I don't recall. It could have been triggered by a question from Ed. I do not recall.
And in the next paragraph down, there's a reference to Charles Brown, who's the auditor at the City of Hamilton. Right. It said the MTO indicated that Charles Brown has connected with them as well last Friday on this matter, as well as several media outlets. Do you recall discussing Mr. Brown's contact with the MTO with Mr. Soldo?
I recall advising him that yes, that Mr. Brown had connected with us as well.
When you say us, was that you specifically, or others at the MTO?
Others at the MTO.
Did you have any knowledge or insight into who it was that Mr. Brown contacted, or what was discussed, or really was this just an FYI?
It was just an FYI. I don't recall anything further.
And you may have mentioned this earlier, but the 4 graphs that you provided, which are referenced here, where did you get that information from, or those documents from?
Through Becca Lane.
So those were documents that Ms. Lane provided to you to then pass on to Mr. Soldo?
That is correct.
Okay. Thank you, Registrar. We can close this document out. And if we could call up overview document 10A, page 106. Thank you. So if we could call up paragraph 262. So the next day, February 13th, 2019, you emailed Mr. Soldo attaching the data underlying the MTO's friction testing graphs and the SMA mix design for the Red Hill Valley Parkway. And the two documents that you sent, the first one was a spreadsheet containing the MTO's friction test results for the northbound and southbound lanes from 2008 onwards. And then the second document referenced there, and I'll call them up for you in a moment, was a one-page PDF excerpt from the Red Hill Valley Parkway mix design. And we asked Ms. Lane about these documents when she testified, and we understand from her that the two documents here that you sent to Mr. Soldo were documents that were provided to her by Miro's staff, and then she then provided them to you. Generally, does that align with your recollection of how you obtained these documents?
It does align, yes.
And more generally, and you've touched on this already, the process, as I understand it, for you obtaining information and documents was sort of through Ms. Lane and her staff, and then that would come to you. Is that correct?
Generally through me to Miss Evoy, to Miss Lane and back. Yes, that's correct.
Okay. And in terms of sort of the work that you were doing on your end, were you doing any independent research or information gathering, or was it all sort of came up the chain to you through staff?
I was not doing anything other than waiting for information from staff, correct.
Okay. Thank you, Registrar. We can close this. If we can call up, I'll just, Mr. Bentley, call up each of the documents that you sent. So if we could call up HAM 54586, and we'll need to call this up in native. Sorry, Registrar. So this is the spreadsheet of 2008 to 2014 test results that you sent to Mr. Soldo. And so what was your understanding, if you had one, of how this spreadsheet was prepared or where the information that was in the spreadsheet came from?
I'm not aware of who prepared the spreadsheet or where the data came from.
It came to you from Ms. Lane or Ms. Evoy, and then you forwarded it on?
As I said earlier, recollection that I reviewed the sheets in this Excel sheet with Miss Lane before having a conversation with Mr. Soldo.
Okay. So you reviewed them before they went out to Mr. Soldo?
Correct.
Thank you, Registrar. We can close this document, and I'll call up the mix design that was the second attachment, which is HAM 54587. Thank you. So, Mr. Bentley, this is the second attachment. Do you recall seeing this document?
I do.
And did you have any understanding of where Ms. Lane or her staff had obtained this information from, or how it came into the MTO's possession?
I'm not aware. I do recall a conversation that perhaps it came from the DSM application by the quarry.
Okay. And that conversation was around the time that you were sending it to Mr. Soldo?
Yeah. Again, it wasn't part of Mr. Soldo's request, but we thought it was helpful to pass that information along. Because we had it in our files, we were unsure whether or not Mr. Soldo had that information.
Right. Okay. So just passing on anything you could find that you thought might be helpful.
Correct.
Thank you. Register, we can close this document out. And if we can call up image 106 of overview document 10A. And also on the second screen, ham 28727. Okay, so you'll see that in paragraph 262 on the left side, that's the summary of the February 13th email that you sent to Mr. Soldo with the data. And then 2 minutes later, you'll see in the document up on the right side of the screen at 3:50, Mr. Soldo sent another note to file of a discussion that you and he had. And so the timing here suggests to me that that you and Mr. Soldo would have spoken at some point in time before your 3:48 email, just based on the timing of when his note to file from your discussion is timed. Does that sound correct? That you had a subsequent discussion and then you sent the data?
That's correct.
Do you recall how the phone call on February 13th came to be and how that got organized?
So can you go, sorry, the 13th? Oh, I don't recall a phone call on the 13th. I only recall the phone call on the 12th.
Okay, so you only recall one phone call with Mr. Soldo?
Correct.
Okay. So the registrar, if we could perhaps call out the note to file that Mr. Soldo sent on February 13th there on the right side. And Mr. Bentley, I'll give you just a moment to review those to see if reading these refreshes your memory at all.
Yeah, that refreshes my memory. So if I could just see when was the date of that, sorry.
Sure, so that's February 13th at 3:50.
Okay.
And just to sort of situate you, this is what I was referring to earlier. There's a bit of crossing. So you send your email with the underlying data at 3:48 that day. And then Mr. Soldo's note to file from your phone call is at 3:50. So okay. Just to sort of orient in time, my earlier question was if sort of the order of events of what happened on the 13th was that there's a telephone call at some point, and then later that day you send, or subsequent to the phone call, you send the additional data.
Correct.
And do you recall if this phone call on February 13th was just you and Mr. Soldo, or if anyone else was present?
I can't recall.
And do you have any recollection of how that phone call on February 13th came to be? We don't see any emails organizing the call between sort of what you sent on February 12th and then your subsequent emails on February 13th after the call.
I don't recall.
And do you recall, and we can call up Mr. Soldo's notes again from the call if that assists, but do you recall sort of how the conversations on February 12th and on February 13th compared, if there was sort of what the differences or what the similarities between those phone calls were in terms of nature of conversation and sort of the tone?
I would say the tone was professional, and it was, again, an information sharing call.
So you were sharing information with Mr. Soldo?
Correct. As you can probably appreciate, we were continue to gather information and was, clarifying and gathering more information as, even between the 12th and the 13th.
Right. Okay. And so the subsequent communications, the phone calls and the email, or the phone call and the emails on the 13th were sort of in continuance of that, the information sharing and clarification or providing additional information?
Correct.
Okay. I'm sure if we could call out the note to file there on the right side. So there, where he references what he says is reintegrated the need for base information, scope of project, and also identified the need for verification of any approvals from the City of Hamilton for this work to take place on RHVP and any transmittals of information during or at the end of the study. So that was, do you recall if those were requests that Mr. Soldo made to you or reiterated to you?
I can't remember him asking a question about whether or not the city was aware of this, of these test results.
And I take it.
And I recall that we were trying to find any documentation in our files about whether or not the information had been shared or not.
Okay. In the second paragraph there, where it says discuss the need for coordinated collaboration regarding communications. Do you recall whose suggestion this was, and why it was needed?
I guess it was a suggestion from our communications folks that they wanted to make sure that they're on the, certainly we're connecting and discussing meeting inquiries to make sure the same, consistent information was being supplied.
Okay.
So I guess that was at my, I instigated that information, asked for that sharing to take place, and identified Bob Nichols as the person from our side.
Right, and Mr. Nichols was who you were referring to earlier in one of the email chains that we looked at?
Correct.
Okay. In the last paragraph there, it says, discuss the need to have an updated friction test undertaken to validate deterioration of pavement friction since 2014. MTO undertook the testing previously in-house and would be willing to do the testing on behalf of the municipality. Do you recall who raised the need, as it's described there, for updated friction testing?
I do not recall that. I do know that the second part of that paragraph, again, based on a previous document that we looked at, that we were to offer assistance to the City of Hamilton. And in that vein, I offered that we would be willing to do the testing. And again, if the city was looking for it to be, consistent with that 2008 to 2004 14 testing, it was something that the city could do, or that MTO could do with the same test method.
Right. that being the locked wheel tester that the MTO has?
Correct.
So you don't recall if it was a request or a question or a need identified by Mr. Soldo, or if it was something that you offered in terms of?
No, it was something that I offered. We offered to do that friction testing.
And the need that's described here in terms of the need to have an updated friction testing done, was that something that you and Mr. Soldo had similar views on in terms of that being needed, or do you recall that?
I don't recall any conversation with the need for the test to be done. I can recall the offer made by MTO to do the testing.
Okay. And in terms of it being, you mentioned earlier that it would make sense for it to be the same method used for the testing to compare it to be able to compare to the 2008 to 2014 testing. Was that something that you mentioned to Mr. Soldo on the call?
In terms of yes, the consistency and be able to compare results, that would have been well, certainly been previously discussed. I would think that I emphasized that again in terms of why we'd be willing to do it. I think that's captured by his note where he said that we had previously done the testing.
Okay. And when you said previously discussed, that you're referring to the February 12th telephone call?
Correct.
Do you recall what Mr. Soldo's response was to your offer to have the MTO do friction testing?
I recall it was kind of a thanks, we'll get back to you.
Okay. So was that the status at the end of the call? It was the city would get back to you about the offer?
It was just an open offer, correct?
Okay. Okay, Registrar, we can close this out. And if we could keep up image 106 of the overview document and also call up image 107. So Mr. Bentley, you'll see there in paragraph 263, which starts on page 106 and carries over to 107. There's another email that you send on February 13th. It's about an hour after your 348 email. So this is the 450.
So could we expand that, please?
Sure. Yes, Registrar, if we could call that out. And then just that top part there. Thank you. And I'll just give you a moment to review your email.
Okay.
So just to summarize in this email, you advised Mr. Soldo that the city requested the 2007 friction testing because of the early age SMA issues, and that the subsequent testing was done for potential use on provincial highways. And that last that reference to potential use on provincial highways, is that a reference to the DSM?
That is correct.
And why were you sending this information to Mr. Soldo? Was this sort of, as we've talked about, just to clarify or correct information that had been previously shared?
That is correct.
Okay. I think some of the earlier emails referred to all of the testing being done for DSM purposes. Is that fair?
That's correct. Although I think if I do recall that perhaps the 2007 results were not included in those Excel spreadsheets that we talked about earlier. They were 2008 to 2014.
That's correct. And I'm going to take you back to that spreadsheet in just a moment. But that's correct. That was just the 2008 to 2014 data.
So on the previous day, it was our understanding, I think it was Becca Lane's understanding as well, that all the testing had been done for I'm going to say for DSM purposes. As we dug into it further, and based on the ... that means that we were still looking at things. Obviously, again, it was trying to go through historical files and find information and so forth was difficult. But from what we could tell, in 2007, those results were specifically requested by the city, versus the 2008 to 14 were as a result of that DSM application.
Okay. So sort of as you said, you were piecing things together based on what you could find in the files and the information, and sort of presenting that to Mr. Soldo, clarifying and correcting as needed.
Wanted to correct that again, that there was two different purposes to the test data, 2007 versus 8 to 14.
And when you refer to we in that top line there, who is the we?
The we was the collaborative effort, but I think that it would certainly include Becca Lane primarily was the, if you want to call it the lead.
Okay.
If you want to call it the researcher or coordinating all the data gathering.
Okay. And so where you write in the fourth line there, no concerns were identified with the initial friction qualities. Would that have been information that Ms. Lane provided to you, or was that information that you gathered elsewhere?
No, that was provided by Becca, and in our conversation about a review of the data.
Okay. And at the end there, where you say, based on a preliminary review of MTO's records and based on the intended purpose of this testing, it would appear that these results were not shared with the city. Do you recall what information this statement was based on, and how you came to the conclusion that at this time it looked like the results hadn't been shared with the city?
So this was in response to Mr. Soldo's request for any documentation around the sharing of information with the city. And as I said, based on this review, and in the matter of, in a couple of days review, we hadn't found any emails or transmittals where the 2008 to 14 data had been shared with the city.
And based on the intended purpose of this testing, that's the intended purpose of the DSM testing? Correct. Can you just explain that, what the significance of that statement is?
So my recollection is that when we're considering an inclusion for, let's say in this case, an aggregate or a stone onto the designated source materials list, there are tests that we do, and one of them is a test section where we can test it for suitability. In this case, friction. And so we were, instead of constructing another test strip somewhere else, which is identifying that this 4-kilometer section of the RVHP was being used as that test section.
Okay, thank you. Registrar, we can close this document, and if we could pull up the spreadsheet that we had open before, which is HAM 54586. So Mr. Bentley, when this is the same spreadsheet that we looked at before, that just has the, as you mentioned, the 2008 to 2014 data. And I believe you mentioned that you referred, or you reviewed these results with Ms. Lane. Is that correct?
That's correct.
Can you tell us sort of when that review happened and what you recall of your review with Ms. Lane?
I recall that it was on February the 12th, based on reviewing them prior to sharing them with Mr. Soldo, and just looking at the data, and for completeness and so forth, and having and noticing, I guess, one other thing I noticed that, I guess, at the time, if I recall, was that there was 1 year that was missing.
Correct, 2013 was missing. And so, as you said, this spreadsheet only includes the 2008 to 2014 data. Do you recall if you reviewed the 2007 results?
I don't recall reviewing the 2007 results.
And do you recall, based on your review of these results, what your view was on the Red Hill Valley Parkway friction test results? And perhaps, Registrar, if we could go to the tab that's called Summary and Plot FN versus Year, that might be a better tab to look at. And perhaps zoom in a little.
So, I mean, in general terms, I guess my conversation with Miss Lane, as I recall, was around, the general, I'll say, decline in the numbers, as one might anticipate as a pavement ages. Certainly seeing some numbers that were below 30, but averages that were above. So nothing really, I'll say, jumped out at me in terms of the data.
Okay. So you noted a decline, but that was consistent with sort of your understanding of how pavements deteriorate over time?
Correct.
And was there anything in these results that caused you any concern or any pause?
Again, not being a subject matter expert in this area, it didn't cause me any concern, or none that Becca flagged at the time. So I guess more accurately for me to say is nothing seemed to be of concern to a strong concern to Becca.
Okay. And if you look in row 10 there, I can appreciate it might be a bit small on your screen, but it shows the lows and the averages for each of the 4 lanes in 2014. And obviously the Red Hill Valley Parkway is a municipal highway, not a provincial highway. But in your view, if you saw these numbers, the averages and the lows here on an MTO highway, do you know what your views would have been with respect to these numbers?
I guess the first thing I would note here, Chris, is these were tested at a posted speed of 90 kilometers an hour, which is not, I can't think of a provincial highway that's posted at 90 kilometers an hour. So typically our testing is done at either 80 or 100. So again, it would be hard for me to make a direct correlation because I'm not familiar with data for testing at 90. You're right, there are some numbers lower than 30, so in generality, but having been involved in years with highways that perhaps we had lower than 30, they didn't seem to be abnormally low, just some isolated ones. The average is still above 30.
Okay. For those numbers that are under 30, would those have warranted any monitoring or investigation?
If this was a provincial highway, I think, the friction number is just one aspect that we consider. You certainly look at the geometrics of the road, collision experience, climate, all different things when you're considering, whether or not to monitor a section of highway. But it certainly would have been worth a review anyway in terms of whether you wanted to do ongoing monitoring.
Yeah. And do you recall if you discussed or shared any of your views about the friction test results with Mr. Soldo after you sent the spreadsheet to him?
My recollection is that we did not discuss the results.
Okay. Okay, thank you, Registrar. We can close this document out now. And if we could call up HAM 48996. Thank you. And perhaps we could either zoom in or call it up. It's a bit small for me.
And me.
Thank you. So this is the next contact that we see between yourself and Mr. Soldo. So now this is about 10 days after the February 12th phone call. And he emailed you requesting a call with MTO's pavement specialists to talk about what type of pavement should be used on the Red Hill, and asking about the MTO's experience with high friction pavement on curvilinear roads. And then you responded, you'll see CCing Miss Lane, as you say, to allow Mr. Soldo to arrange a meeting with her and her staff. And so do you recall if at this point you sort of had handed things over to Miss Lane, or if you were sort of still involved directly with Mr. Soldo?
My recollection is that I basically handed this over. I mean, they were now getting into technical specifics that Miss Lane was much more qualified to speak to when you come to pavement design and friction testing. And my recollection is that my instructions were to Rebecca to, again, to offer assistance to the city of Hamilton as we were instructed to do. So again, trying to be helpful. And basically, in terms of handing it off, my recollection was to just sort of keep me in the loop and let me know if there's anything that I need to know in terms of anything of concern to her in terms of things that were not happening or questions being asked that I should be of concern. So basically handing off it to her and continuing to and asking her to follow up with me as needed.
Okay. And would you say sort of, we know that there are some subsequent emails between Miss Lane and staff at the city of Hamilton, some of which you're copied on and some of which you're not, but would you say that sort of reflects your role and Miss Lane's role as of this point, February 22nd onwards?
That's correct.
We've looked at a number of sorry, Roger, we can close this out now. Thank you. So we've looked at a number of email chains and where you've provided information and documents to Mr. Soldo. And as you sort of described the calls that you had with him, it was an information sharing on your part with him. Do you recall if you ever received any documents from him during your discussions, either consultant reports or friction test results?
I did not receive any documents from Mr. Soldo to the best of my recollection.
Okay. Register, we can close this out, and if we could call up overview document 10A, pages 186 and 187. So now, Mr. Bentley, jumping forward a bit in time to March 2019, you'll see in paragraph 481, which continues on page 187, Mr. McGuire emailed Miss Lane on March 20th under the subject line, follow up with the city of Hamilton. Perhaps, Registrar, we could call up Mr. McGuire's email, which is the top of page 187. Yeah, thank you. And so in the second paragraph there, he says, I wondered if we could have a conversation about the potential to test our facility again prior to our resurfacing works. And then asks if at the end there, if we could arrange a call in the next week if Miss Lane was available. And Registrar, we can close this out. And I can summarize Miss Lane's response that she provided a contact for Mr. McGuire with somebody else in the MTO. And then she says—
Totally unrelated matter.
Yes.
It was both liquidated damages, yeah.
Okay. And then with respect to the friction testing, she said, with respect to friction testing, I will check with staff to see if the friction trailer is ready to hit the road. We will need some warm weather. Stay tuned. So just to clarify for you, you were not copied on this email. But at this point, were you still in the loop, so to speak, about the city of Hamilton friction testing and sort of any advice that Miss Lane was providing on resurfacing?
No, I mean, I don't have any specific conversation with Becca, but it's not that I didn't, speak to Becca. I mean, as you can appreciate, there was lots of pavement issues.
Right.
That we would have discussions on. So I can't recall having a specific conversation other than and maybe this will come later on, I do recall saying, what's happening with testing? Where are we at with that? Because my concern was that we didn't want to be seen as not being helpful as we were instructed to be.
Right. Okay. And that takes us then to you'll see sort of register, if we could call it paragraphs 483 and 484. There was a call arranged about 9 days later on March 29th. Felicia Haringa sent an email to Mr. Soldo. And in her email, she wrote, Kevin Bentley and Becca Lane from the Ministry of Transportation have asked that I schedule a 30-minute meeting with you about the MTO undertaking friction testing. So is this what you were referring to when you said that you'd been asking sort of what's the status with the friction testing?
That's correct. And Becca saying she didn't know.
Okay. So this was to sort of check in with the city about your request and the status?
Correct.
Sorry, your offer. And then you'll see that there was a calendar invitation circulated for a meeting on April 2nd with the title MTO Undertaking Friction Testing. Ms. Lane, Mr. Soldo, and Mr. McGuire were listed as the required attendees for this meeting along with you. And generally, can you tell us about what the purpose of this meeting was beyond sort of what you've just told us?
Not beyond it, and I have no recollection of that meeting on April the 2nd.
Is that you don't think it happened, or you just don't recall either way?
I don't recall either way.
So I take it then, based on that, you don't recall what, if anything, Mr. Solder or Mr. McGuire said about the MTO's offer to perform friction testing?
That's correct. And just as clarification, when it says Mr. Bentley circulated, of course, that would have been actually Miss Haringa, with access to my calendar, who would have actually sent out the appointment. Right.
It would have been Miss Haringa on behalf of yourself.
Correct. So, and I said no recollection of whether that meeting happened or didn't happen, and what was discussed at the meeting, if it did happen.
Okay. And we know that eventually there was no friction testing conducted on the Red Hill Valley Parkway by the MTO in 2019. Do you have any insight into why it was that offer was never taken up by the city?
I have no information on that.
Do you recall how those discussions with Hamilton about the testing concluded, or sort of where they were left at?
To the best of my recollection, nothing after March, after conversation, that this kind of March 29th, April 2nd, I don't recall anything further of any further discussions with Hamilton about the offer to do friction testing.
But from your perspective, the MTO was prepared to do that testing if the city had wanted it?
So from my recollection, yes, absolutely. We had made the offer, and to the best of my recollection, Hamilton never got a request from Hamilton to do that testing.
And after this April 2nd teleconference, which I appreciate you don't recall,
Right.
But after this point, do you recall if you had any further substantive involvement with the Red Hill Valley Parkway or the city of Hamilton on these issues between April and June 2019 when you retired?
I do not recall. The only other issue that I can recall happening in that time frame was, and I don't know whether it come in yet or not, was a request from the city of Hamilton for an apology from the ministry. But that was, the response was dealt with after I left MTO.
Okay.
So that was the only thing that I'm aware of, was that request for an apology.
Okay, but that ultimately concluded after you'd retired? That's
correct. But if you want to say it on a technical basis, I wasn't aware of anything else from the city of Hamilton.
Thank you, Registrar. We can close that out. Commissioner, I have no further questions for Mr. Bentley.
Thank you. Should ask whether any of the participants' council have questions for Mr. Bentley. Start perhaps with council for Golder.
Good afternoon, Mr. Commissioner. I do have one question for Mr. Bentley. You had spoken earlier about your awareness of friction testing methods, and in that context, you'd spoken about stone mastic asphalt. Do you recall that, Mr. Bentley?
I do.
Could you tell us what percentage or how much of SMA is used on MTO highways in Ontario?
You mean currently, or in what time frame are you speaking to?
Right. I guess historically, is it widely used? 1/3 of highways in MTO have SMA, or do you have a sense of how much of SMA is essentially used?
Today, I don't. Obviously, I retired in 2019.
Right.
There is a history that other people from MTO can speak to, obviously better. But my recollection is that we had started, I'll say, trials of SMA back in sort of the mid 2000s. And maybe had done one project even earlier than that, but it wasn't being widely used by MTO. Other friction courses, different pavements were being used more widely than SMA.
Right.
So
go ahead. Sorry, please finish.
No, I just say, so again, it depends on the time that the particular year. It varies dramatically in terms of how much SMA that the ministry used.
My recollection is that perhaps the first trial was in 1996 on one of the 400 series highways. Is that accurate, or does that align with your recollection?
My recollection is there was one trial project done in the mid to late 1990s.
Okay, all right. Those were all my questions. Thank you, Mr. Bentley. Thank you, Mr. Commissioner.
Ms. Talabi for the city.
We have no questions for Mr. Bentley this afternoon, Commissioner. Thank you.
Okay. Thank you.
And I can confirm that MTO has no additional questions for Mr. Bentley either.
Thank you very much, Ms. McIver. And I don't think Dufferin is on the line. Is that correct, Ms. Hendry?
That's correct.
So does that concludes Mr. Bentley's testimony. So thank you very much, Mr. Bentley, for appearing this afternoon. Appreciate your time. You're certainly excused, and I think we're now going to take a break until 3:30. Is that correct, Ms. Hendry? Until
I believe that's the timing.
okay, until we begin hearing the motion for directions from the city's auditor with respect to the summons that's been issued to the auditor. So we'll stand adjourned then until 3:30.
Thank you.
Good afternoon, Commissioner.
Good afternoon.
For the remainder of today, we have brief oral submissions in respect of a motion brought by the Office of the City Auditor in respect of a summons that was served on Dominic Pellegrini, a individual within the auditor's office. Just to orient you to the process leading to today. For the remainder of today, we have.
Oops.
Apologies, Commissioner. That was an unfortunate tech issue. Hopefully you didn't have too much issues in hearing me. I'll start again. We are proceeding today in respect of a motion that was issued to Mr. Pellegrini, who is in the Office of the City Auditor. The motion today is seeking the attendance of Mr. Pellegrini. Pardon me. The summons is seeking the attendance of Mr. Pellegrini at the hearing. The Municipal Act requires that representatives from the Office of the Auditor must preserve secrecy in their work, and that its staff are not competent or compellable as witnesses in civil proceedings. Given these provisions, there is a motion for direction before you because, of course, both Commission Council and the Office of the City Auditor do not want anyone to be offside the Municipal Act provisions. And so we have worked very cooperatively and efficiently to bring this legal issue to you, the legal issue being whether Mr. Pellegrini should be called to testify, given the Municipal Act provisions. We opted for a motion in writing, and I know that you have received and reviewed the FACTA from both parties and a letter from Council for the City, and you have sought very brief oral submissions today. So with that introduction, and apologies for the technical issues, I suggest that we proceed to the brief submissions in this motion. Thank you.
Okay. Thank you, Ms. Lawrence. I propose that we proceed in the following way. I hope with the concurrence of council. First of all, Mr. Ukvi, I hope I pronounced your name correctly. I would appreciate receiving brief submissions from you. Before you do that, by way of overview, first of all, I have read several times the FACTA, tried to understand I think I understand the issues. As I see it, there are really two separate arguments, perhaps they're related in some way that you raise. The first is that the effect of the summons is to investigate the investigator, as you put it. I'll come back to that in a second. The second is really based on the existence of the secrecy provision. If I understand the first argument, my question is whether that is resolved by the limitation expressed by Commission Council with respect to the testimony that they seek, which doesn't engage the conduct of, it doesn't bring into question in any way in the course of this inquiry, as I understand it, the propriety of the actions, of any actions on the part of the city auditor. And I think at a point in your factum, you more or less acknowledge that by saying or acknowledging that there is no question of political or other activity that brings the independence into question, but that this is more a matter of principle for you. And the second question is the one that I'm more interested in, and that is really the purpose of the secrecy provision, specifically, and what is the purpose as you see it of the secrecy provision, in whose favor does it run, and what is the significance of that for the issue before us. So with that said, I'll be happy to hear your brief submissions, and then we can take it from there. I should say before we proceed as well, I know the city has indicated that they do not take a position on this motion. I'll just confirm that, or alternatively, Ms. Talebi, give you an opportunity to speak if there's something that you feel you should address after hearing Mr. Ukvi's submissions before we hear from Commission Counsel.
Thank you, Mr. Commissioner. I can confirm that still remains our position. We don't take a position in this motion.
Okay, thank you. Okay, Mr. Ukvi, it's over to you.
Thank you, Commissioner. Thank you. The pronunciation of my surname was very good. So it was you even Estonianized it enough that it made me feel at home. I think that you fairly summarized the first argument. I think that they are intended to show two separate arguments, but they're somewhat interrelated. Just from the perspective that it really stems from a holistic interpretation of the provisions of the Municipal Act that give the powers to each of this Judicial Commission as well as to the Office of the City Auditor. And so both issues kind of spin out from that singular, the interpretation of the Act. I don't propose to get into any detail on statutory interpretation or any of those and bore anybody with the rules of statutory interpretation, but I will make some reference to those provisions. I'll start with the second question, or the second piece that you're most interested in the secrecy provisions, and really start off with the observation or commentary that if a matter is to be statutorily required to be kept secret, and your question was secret from whom, I think is sort of the nut of what you would like addressed. And in the way the Municipal Act really operates is that it's secret from the people that are being investigated. And so like secret from council, for instance, if the council's being investigated, or secret from the municipality, because the job of the Office of the City Auditor is to independently go in and look at what is being done and conduct any number of different kinds of investigations, which run from anywhere from value for money all the way through to serious frauds or other types of those, which have all been downloaded to the Office of the City Auditor as a function of ensuring that there's transparency into the operations of a municipality. And so if the goal of a provision is to keep secret from that municipality what it is that the Auditor General does, and I'll get to this provision more specifically, with only two exceptions in the specific provision, being one, if there's criminality, then the criminal code would allow that information to be accessed, or in circumstances where the Auditor General decides to report out, then the purpose, I'd suggest it's a perverse result if the municipality can then go order a judicial investigation, an investigation, judicial or otherwise, that includes or requires the disclosure of that secret information. And so this goes back to the sort of this overarching theme that I think I had in my factum, which was that you have, in many of the cases that have been considered to date, the look has been a question of, well, you've got a lieutenant governor ordering a judicial inquiry or public inquiry into a matter where it's under, like maybe there were actions taken under a specific statute, but it's different in this case because the municipality, both audits, or the inquiry and the audit, are happening under the same statute under almost parallel provisions. And so from that perspective, I would suggest that if the secrecy is from the municipal corporation, to allow the Office of the City Auditor to do its work. And both the judicial inquiry and the Auditor General are brought into existence by a decision of the Municipal Council. They're sort of both operating underneath that direction. And so because of that, I would suggest it's a strange result to be able to first get the results of an Auditor General's work and then decide, well, we're going to have a judicial inquiry of that. Now, I appreciate that the judicial inquiry in this case is much broader, but that would sort of be, in a nutshell, how I think that secrecy provision is intended to operate. And so from that perspective, it would seem that both, whether it was the Municipal Council acting on its own decision or through a judicial inquiry, the Office of the City Auditor can't be at the mercy of the Municipal Council, and it's at that position or that point where I think it brings into sharp focus the purpose, in my view, of what that secrecy provision is. And I don't think it can be overemphasized that a municipality does not enjoy an independent constitutional existence as well. And so it is really driven from the language of the statute. They hold delegated powers. And so because of the way that the whole rubric has been set out under the statute, when you flow it through, both operations or both sets of investigatory powers being exercised are coming from the same place, which is the Municipal Council. And maybe I'll just conclude sort of my remarks on that by saying that if you're left with a question at the end of the day, what's the city's remedy if the Office of the City Auditor improperly exercises its jurisdiction, and can it somehow get behind it? Let's say the Office of the City Auditor goes rogue. The answer, in my view, is quite straightforward, and that's that there's an administrative decision-making process. That means that it triggers a process under the exercise of a statutory authority, which means that it's subject to judicial review. So there is a process if there is something that is done untoward in the Office of the City Auditor. It just can't be a parallel process, but rather it has to be following the Judicial Review and Procedures Act, which brings in obviously a different standard of review to the conduct of the Office of the City Auditor than is otherwise available through the judicial review process.
Well, I accept much of what you say as starting for this. There are separate jurisdictions which stem from the same provision of the Public Inquiries Act. And I think we would agree there can be considerable overlap in terms of what the City Council asks each entity to investigate. That doesn't strike me as the end of the discussion, more like the beginning. And I accept what you say about the ability of the City Council to seek an administrative law remedy if the auditors were to go rogue, as you put it. Setting that aside for the moment, my first question is, much of this seems to be premised on a perspective that the summons involves investigating the Auditor General, and I don't understand the request for testimony in this particular case to engage that issue. And I'm not sure you do either.
I agree with that. So that's we're coming back to your first question, obviously.
Okay.
Yeah.
But am I right? You don't see that as engaged in this particular case. You are just concerned that a decision in this case could be used for that purpose in another case.
And quite broadly, not just in the context of an Auditor General, but also in the context of an integrity commissioner or an ombudsperson. The challenges are quite broad because all of the provisions through all of 223.1 1 and onwards are all similar. And so the ramifications of this decision are, it's sort of, it does create an important precedent, because these provisions, this circumstance has not been considered. And so I certainly have worked very carefully with Commission Counsel to try and narrow the issue as much as we could. Right. And I do thank Ms. Lawrence for all of the assistance that she provided. And she was very fair in identifying the exact things that she wanted to understand. And in this case, that I understand exactly what you have said, is that it's really a process-oriented questioning of how this report made its way from being discovered through to the report out to council. And how, but at the same time, that's still going into very much what the Office of the City Auditor did. And so that is definitely a concern. And I don't have as easy a time separating whether it's sort of the conduct of the Office of the City Auditor versus the process of the Office of the City Auditor. I don't see there being as clean a distinction, perhaps, as Ms. Lawrence was trying to draw. And that's where I think that my concern lies in terms of the jurisdiction about the ability to get behind that process.
But I can't speak for Ms. Lawrence. As I look at this, what's sought is evidence with respect to the actions, not of the Mr. Pellegrini, really, but the actions of city employees who interacted with Mr. Pellegrini. That seems to me to be qualitatively different.
Yes. And it's the fact that the only reason those individuals are interacting with Mr. Pellegrini that creates the problem, because he was only doing that job exercising his authority as an investigator in the Office of the City Auditor.
Yes, but it seems to me to be a long way away from investigating the investigator.
Right. Okay. I take your point. But it's still sort of collecting the information that Mr. Pellegrini obtained through that process, and it may or may not be useful to this commission in terms of the ultimate outcome and the recommendations that are ultimately issued by the commission. But it still comes back to the issue that Mr. Pellegrini was only able to get there through the exercise of his own authority.
So let me take you to the secrecy provision.
Yeah.
Is there any reason why the city couldn't waive the secrecy provision?
Oh, I don't think that the city could waive it. I suppose the question is whether
could the city ask for a report on the very matters that the Commission Council seeks the evidence?
I actually not if the Office of the City Auditor were to remain independent. The city couldn't direct the Office of the City Auditor to report on anything. I mean, in the Office of the City Auditor's charter, it specifically says that they're to engage in and report on and look into and investigate anything that they want to investigate. So it would go again, they'd have to change that charter. And in which case, if they did, I'm not sure that it would.
Isn't that? I read the charter differently. It seemed to me that the city auditor is entitled to commence audits on its own, clearly. But I didn't read it to the effect that the city could not request an audit on a specific subject.
No, I suppose, yeah, okay, take your point. I agree that the city could request an audit on a specific thing, yes.
So could they not request a report on the very matters that are the subject of this?
Yeah, and I suppose that by extension, that would mean that you could order the city auditor to produce a report on the substance of this matter. If I follow through that to that extension.
That's where I was going. Yeah.
Yeah.
And so when I step back from that, it seems to me two things might follow from that. The first is that it would appear that the secrecy or confidentiality provision really runs in favor of the city. And I would add to that, I'm not sure there's any right by which a party being investigated can enforce confidentiality.
No, I agree with that. Absolutely not, because the Office of the City Auditor makes the decision on what to report in his or her own discretion. Is what gets released through that report.
Right.
And so the question, I guess, to get right down to the heart of it is if the city requests an audit of a specific issue, or you were to order the Office of the City Auditor to produce or audit or report on a specific issue, whether there's any discretion in the Office of the City Auditor in deciding what it is that they produce or report. And I think that that then goes to the heart of the question of independence. And if the Office of the City Auditor doesn't have discretion on what it is that they report on or how they conduct the audit, then they're not an independent arm anymore. They're not conducting an independent audit.
That's perhaps a more extreme view of independence. Independence goes more to the investigation. Nothing in the nature of the circumstances that we're discussing would go to inhibit the investigation. It would simply be a report with respect to specific matters after an investigation commenced by the Auditor General or the City Auditor. I go one step further, and that's the reason why I've proceeded down this road. If the city has the right to do what we've just said, then shouldn't that inform the view of the operation of the secrecy provision in the context of a summons?
So, I mean, I think the secrecy provision is slightly different than I like. I mean, I read it to say that it's so I like. I'm reading the secrecy provision again here. It's section 223.22 sub 2.
Mm-hmm. I'm not so much interpreting the confidentiality provision or secrecy provision as asking whether that circumstance shouldn't inform the relationship between that provision and Section 33 of the Public Inquiries Act. Your position is that there's a conflict, and the Commission Council's position is there is no conflict. I'm trying to address the question in that context, and I wonder if the logic of what we have just discussed wouldn't resolve that question.
You certainly, I mean, you've given me a question that I mean, I'm usually so much quicker to.
No, it's quite all right. I'm quite happy to have you think it through. But it's that which came to my mind when I read the materials, and because it wasn't specifically addressed, I thought I should give you the opportunity to be aware of what I was reflecting on and to respond.
Yeah, and I think it's I mean, obviously it's a challenging question.
Yeah.
When you flow the logic through, it runs that if the city can order the Auditor General or request or direct the Auditor General to produce a specific kind of report. Does that then mean that the city does that inform a secrecy provision?
Not so much the secrecy provision as the question of potential conflict between Section 33 and the secrecy provision.
But the conflict continues because the secrecy provision is there to put a shield around the work that the Auditor General is doing. It's not there to it's not there to protect the fact of the audit. It's not there to protect the directions an Auditor General has received from council to do specific kind of work. It's there to protect the work itself and the work product itself. And so if the work product itself is protected, and there continues to be a conflict between two levels that are looking into the same issue. I think I appreciate the question you're asking, and I just continue to have a concern that the nature of the question, if the secrecy provision puts a cloak around the work of the Auditor General and not the audit itself or the directions received, then it still has to go to the very, very issue that's being looked at here, which is Mr. Pellegrini's work while he was working on a question. It was a self-directed question, obviously, by the Office of the City Auditor, but I think that's not relevant for this discussion we're having, because it really doesn't matter if it's the city directing the audit or whether it's the Auditor General acting on its own independent jurisdiction as given to it through the charter. It's the question of when does that secrecy begin, and at what point does that sort of cloak of secrecy shield the work of the Office of the City Auditor. And if you're able to go in and start saying, well, okay, if we're just going to look at the procedural stuff that Mr. Pellegrini did, or ask him questions about the work product that he obtained from the city, it really loses the purpose of the secrecy provision from the city council. So asking the question in terms of how the city council can direct and whose secrecy it is to waive, it has to be the Office of the City Auditor's secrecy as an independent body to protect the information it collects. And then once it reports out on that information, then that report goes back to council and is a public document. But it's the sort of the way the sausage is made, and I would include in that sausage making process Mr. Pellegrini's work when he went in and interviewed city staff.
Well, another question I have is, how can it be confidential when you're talking about a report that the city wants about how its staff reacted as employees when they, in this case, learned of a document? But you could just as easily say, how can it be confidential if the question is from the city, if the question is about corrupt practices on the part of an employee? Surely the city is entitled to call for all information relating to an investigation which the city auditor instituted on its own behalf, if you like, with respect to corruption on the part of its employee.
And I think that's the awkward issue that we're dealing with, because the Office of the City Auditor wants to help. Like they,
I understand that.
It's not like, and so the challenge, I think that it's almost like bad facts make bad law here. And I'm worried about, the optics of this, because it's certainly not the intention of Mr. Pellegrini or the Office of the City Auditor, and specifically to try and shield information that would be important for the commission's decision-making process. But if we were to take a step back and say, well, what do you know and what do you have? You've got a report, you've got a redacted report, and you've got a report to City Council saying, here's a problem. How do you want to deal with it, Council? We're stopping our other investigatory process in order to tell you about this thing that we just found, this report, this road friction report that we found. Like it's like that was a 2-month period of time, and how city staff reacted. Well, I mean, is it really required to get into that with what the investigator heard at that moment in time? Would it be nice? Sure. Maybe the appropriate thing is for the Office of the City Auditor to report on it, or finish a report that it just didn't do because of the inquiry.
Sure. Well, I think that I'm not sure. At one stage in your factum, you suggest that the evidence that's sought is not relevant. I'm not sure you're really pushing that.
I think that my concern that
how it isn't relevant, but let me just put the last question I have, which follows really from the point that you made. If the alternative is to request a report on these very matters, is for City Council to request a report on these very matters, which you say would be within the jurisdiction of the City Council and would require disclosure on the part of the auditor. Hasn't the City Council already effectively done that by setting the terms of reference?
They have not directed that the Office of the City Auditor report on it in the usual way to City Council. What they have done is they've asked for an inquiry to be done, and I accept that literally they have not required such a report. I guess my question is more from a substantive point of view. Have they not asked that the city auditor provide a report which will be conveyed to the inquiry? And in that sense, should that perspective again not be the one that informs the issue before us today? Well, it's a bit of a difference in kind, though, and I think it's not an insignificant difference in kind, because the preparation of a report and reporting to council or reporting to the commission is a different process than subpoenaing a witness who isn't necessarily going to be the author of that report or presenting it to council. So I don't mean to make it sound like it's a hair splitting exercise, and because I do think that there's a difference in kind. I'm like you, trying to identify whether there is a dividing line between the circumstances where you see Mr. Pellegrini can assist the inquiry, and beyond which you say the inquiry cannot or should not proceed. I invite you to, if you have thought of that, whether there is such a dividing line. And I would suggest that the statute provides a dividing line, being that the the report itself could stand on its own and be filed with the commission, but giving evidence on that report and how it came about and questioning on the content of the report is outside of the purview of the commission. And so if the commission were to report, or Office of the City Auditor were to report on the outcome of a process, it would still not be within the purview of the commission to then go and ask more questions about the process or the outcome of that report.
Effectively, you say there is no dividing line. I was inviting you to reflect on whether there are circumstances where the independence is engaged as opposed to the circumstances where it is not engaged. I'm not trying to make you say something that you're not comfortable with, but your response suggests that you don't see, put another way, I may or may not agree that this is a case of bad facts make bad law. Is there a way that you can deal with the bad facts in a way that produces law that's acceptable to you, but is consistent with what Commission Council is trying to achieve?
Well, I mean, I guess it's at what point can you break down independence, and what does independence mean? I suppose, like, back to your question of I mean, you asked me quite, and you felt I was going too far and far on what I believed independence to mean, and properly stated, my view would be that if a process is to be independent, that the decisions of what to report on and what not to report on, in the context of an investigation, would have to be in the discretion of the Office of the City Auditor to make that decision for independence to exist. Or perhaps it's maybe not even, maybe it's a little bit more subtle than that. Maybe it is that the conclusions that you draw from a set of facts that you discover are the ones that are subject to the independence. And maybe that's where I'm struggling about, because facts are obviously facts.
Yeah.
And if a known set of facts is put to a city auditor to report on, or it's same thing with the judicial inquiry, then I would suggest that the conclusions drawn by the Office of the City Auditor are definitely subject to their own purview. So I'm very comfortable with that spot. The question then becomes, how much farther does it go to protect the process beyond just the conclusions drawn from known facts?
Yeah. And this engages, as you undoubtedly accept, something other than the conclusions. It's not the conclusions or the reasons for the conclusions that constitute the testimony that's sought here.
I accept that, and then taking it to the step then to say, and this is where I think that some of my commentary about relevance came in, and perhaps I used perhaps the wrong legal principle on it, but it really is the fact that the evidence being sought from Mr. Pellegrini is partially either to corroborate or to call into question other evidence that's been heard. It means that it's sort of calling for somebody to provide their, if it goes beyond, let's say, their observations or what somebody told them at that time, that whole process engages the investigation. And so that's where I don't know that there's a bright line, but it's getting really close to that spot where you're talking about somebody that went in, made a decision to ask some questions and got some answers from the individual. That questioning process is where it's a question of, well, what are the facts? What are you calling on Mr. Pellegrini to provide? And what I see there being, the requests are being made is for evidence to talk about things that either a witness said, didn't say, and to look at what it is that they remembered when they gave evidence to this commission, and to compare those notes. That's
how does that engage issues of independence on the part of the Auditor General?
Well, and that's where I think that I think that's where I'm struggling to provide you with a very clear answer, because I'm certain and confident in my response on the question of the conclusions and the decision-making process. I'm admittedly less certain on the fact-finding exercise, but I still think that for me, it goes a little bit, it has to go farther than just the conclusory and decision-making process. Otherwise, you end up risking making any investigator a witness anytime there's an outcome that a city doesn't agree with or doesn't like, or they don't like the process. So rather than engaging the judicial review process and looking into the reasonableness of the decision-making process, you are now much more directly engaging at the heart of the Auditor General's jurisdiction and their authority under the Municipal Act. And that's where my discomfort lies about going and why I think it goes further than simply just the conclusory and decision-making process within the Auditor General's office.
So you see this ultimately as engaging or opening the door to an alternative process to judicial review of an inquiry that City Council is not happy with.
That's one of the, and I don't mean just to Hamilton City Council.
No, I don't mean that.
I just mean municipal.
City Council is not happy with. You're saying it opens the door to an abusive process that would be implemented by way of a judicial review of the investigation.
And because, I mean, yes. And I think that the reality is that a judicial review process is in many cases and in many circumstances very unsatisfactory to the applicant bringing that judicial review, because all they're allowed to do is challenge the reasonableness of the decision, as opposed to the content. And that's seen from that from the DiBiase decision as an example of the they couldn't get behind that provision. And so like that wasn't put there to say that, I mean, that decision was just there to show you how the judicial review process should work. And so that's, and I do have a very significant concern about that. And
ultimately, I think maybe that is your concern.
Yes.
Right. Okay. Well, I have no further questions. I'll let Ms. Lawrence speak to the issues that have been raised, to the extent she wants to add anything.
I feel better for Ms. Lawrence because she's had some time to think about your questions.
You have a few minutes by way of reply.
All right, thank you.
Thank you, and I thank you, Commissioner, for your questions. I think it was very useful to better understand the parties' positions. As you will have seen in Commission Council's submissions to you, Commission Council is proposing to examine Mr. Pellegrini on very limited points. One, how he came into possession of a redacted copy of the 2014 Golder report. And that is, broadly the details of who provided it, how he received it, and when. Second, how he came into possession and any agreements before he came into possession of an unredacted copy of the Golder report and the Tradewind report. And then finally, to the extent that Mr. Pellegrini may have evidence, Mr. Pellegrini's meeting with Mr. Moore on February 4, 2019. So it's quite limited in terms of the information that Commission Counsel is seeking to elicit from Mr. Pellegrini. And it goes to, as my friend put it, either corroborating or calling into question evidence of other witnesses. And perhaps put differently, it deals with the context of city staff and how they were dealing with the issue of the Golder report and the Tradewind report. These are obviously highly relevant to several of the terms of reference that are before you. The summons does not require Mr. Pellegrini to provide any documents, any work product prepared by him or others within the Office of the Auditor, nor except to provide a little narrative, is requesting him to speak more broadly about the work of the auditor. And so you have, so just that context, I think, is useful given the discussions that you had, or the interaction you had just now with my friend about where the line is on what and when an auditor should be compelled to provide information to an inquiry. And so I certainly understand my friend's concern, the policy concern, that judicial inquiries called by municipalities could be used against their independent bodies like auditors or ombudsmen. That is not the issue you have before you here. That is a policy concern that frankly should be assessed on the facts of any case if that ever arises. And I would anticipate that using other common law remedies, in addition to judicial review, having that kind of misuse of the judicial inquiry process could be resolved in an appropriate way by the courts. Rather, what you have here, Commission Counsel submits, is the clear application of what the Municipal Act permits. The judicial inquiry process is really quite unique and rarely used. It is intended to engage a fact-finding process, and as you know, you have certain terms of reference that limit the scope of your inquiries. It's undisputed, as between the parties, that the inquiry has the power of summons under Section 33 of the Public Inquiries Act. And the only restriction on the ability to summons evidence under that section is that the evidence is relevant and not privileged. We spoke, you spoke with, you had the back and forth with my friend just now was about the Municipal Act, and there are several sections that are relevant here. The first is Section 223.2 of the Municipal Act, and I'm happy to have the registrar put these up if that would be useful, although I know you have hard copies of the Municipal Act.
I can look too.
So that provision says every person acting under the instruction of the Auditor General, so here, Mr. Pellegrini, is to preserve secrecy over all matters that come into their knowledge in the course of their duties. And you did have some back and forth about what are the course of the duties? Is it conclusions? Is it the fact-finding work? Is it the work product? And I submit it is all of the above in terms of preserving secrecy. The Municipal Act does not draw a bright line in terms of where the preservation of secrecy begins or ends. However, that does not end the analysis. The preservation of secrecy is one of several related and interrelated provisions within the Municipal Act. But starting just with the preservation of secrecy, preserving secrecy or any other duty of confidentiality that's in a statute does not mean that the work of, in this case, the auditor is always immune to being produced pursuant to summons. In fact, quite the opposite. Statutory promises of confidentiality don't bar the production of by summons of information in the holder's hands unless it is privileged or the legislature has used language specifically prohibiting its introduction. So recognizing that the policy concerns around independence relating to auditors in particular, as an overarching principle, it is only where the legislature has expressly prohibited information from being compellable by summons that information will not be disclosed. So I would take it that there's nothing about the auditor in particular or his independence that changes that statutory interpretation that you must apply here. And that principle has been, well trod in the case law, including the Transamerica case that we have in our factum, and the two inquiry decisions. One, the pediatric forensic pathology inquiry, which ordered the disclosure of information from the CPSO, who was a holder and had a duty of confidentiality, and Commissioner Linden in the Ipperwash public inquiry, who ordered disclosure of information in the police, who also had a duty of secrecy. So, of course, the police, the College of Physicians and Surgeons, who has an investigatory powers, and the auditor are all very different entities. But it's clear that on its face, you must look to the legislature and the legislation to determine what can be excluded and what cannot. And we should do that before we overlay any issues around independence. There's no explicit language in the Municipal Act that bars production by summons. So then you have to look, I think, to the language that is there to interpret whether you can harmoniously and coherently read the Public Inquiries Act with the Municipal Act. And I submit that you can. And you can specifically in the context of judicial inquiries. They are unique and different, and they serve an important role that is not expressly referenced in the Municipal Act, but needs to be reflected in an appropriate statutory interpretation. So we went to the broad, preservation of secrecy, that obligation. And I agree with my friend that obligation is to cloak the work of the auditor during the investigation process. That is not unlike the duty of confidentiality that CPSO investigators have, nor that police have. It's all for the same purpose. The Municipal Act has two particular express exceptions for around the preservation of secrecy. So persons are required to preserve secrecy and shall not communicate information to another person around the course of their duties, except in connection with the administration of this part of the Municipal Act, including reports made by the auditor or under the criminal code. And so there's no global, universal preservation of secrecy. Obviously, issues of criminality can be communicated outside the auditor to another person. And where appropriate, issues in the context of the administration of the auditor's work. I think I heard my friend's argument to be that where the auditor is of the view that they should report their work, they have the discretion to do so. And I don't take issue with that position, but it does certainly, in my view, in my submission, demonstrate that where the auditor decides to report and they do have an ongoing reporting obligation to council under the Municipal Act, that the spirit of the Municipal Act can be read harmoniously between the idea that there could be a judicial inquiry seeking evidence and, in a parallel process, the auditor making a report. It is also my submission that the fact that the auditor could be compelled to provide a report to the City Council if requested also demonstrates that the secrecy provisions are not watertight and that they need to be interpreted holistically within the Act that also permits the judicial inquiry process. The last aspect of the Municipal Act, which may be useful in the statutory interpretation to find a way to harmoniously read the auditor's role and the judicial inquiry role, is the provision that specifically precludes persons acting under the instructions of the auditor from being compelled to testify in civil proceedings. As well established that public inquiries are not civil proceedings. They don't enforce or vindicate private rights, and there are no legal consequences that flow from determinations of a commissioner. And so taking these provisions together, the auditor must preserve secrecy, except in connection with the Act, including providing reports, which in this case, the request for a report was superseded by the terms of reference and the initiation of this inquiry, or in connection with their criminal code. But that secrecy is has nuance in that the auditor could be required to produce documents or information when summoned by a person with authority to do so. And I recognize my friend's position that the independence of the auditor could be affected by that. In my view, you have to look to the Municipal Act, and the fact of independence does not change the way that the Municipal Act reads. And looking at the common law, it's very clear that if a person has authority to issue a summons, then the recipient of that summons must comply unless there is some valid reason, including privilege, to object to doing so. Here, it's very clear that the Municipal Act prohibits the office of the attorney, the office of the auditor to be a witness in civil proceedings. And so the Municipal Act has said, yes, there's secrecy. The common law has said, but sometimes the auditor will be required to produce documents. And the legislature has said quite clearly that they may be compellable or competent witnesses in non-civil proceedings. So where does that lead to? Reading that, the interpretation of the Act and the case law, Commission Counsel submits that there's reading those two things together. The judicial inquiry process is one specific and frankly unique place where an auditor may be compelled to testify and to provide documents to the extent that those documents are relevant to the judicial inquiry. It would be entirely contrary to the purpose of the inquiry and the fact that the Municipal Act provides for a judicial inquiry process if the Act limited the ability for City Council, one, to make the choice between using the auditor process or using the judicial inquiry process, and then limited by implication the ability to seek information from any source, including those who report to council like the auditor. The Municipal Act simply shouldn't be interpreted and wouldn't have been written to restrict the judicial inquiry's ability to obtain such information without very express language making that clear. So on very last issue, this issue of independence and whether that layered onto this interpretation changes the analysis. In Commission Counsel's submission, it does not. Well, again, going back to recognizing the concern that the auditor and those similar to the auditor, like ombudsman, might have, it is Commission Counsel's submission that the act must be interpreted to provide for that very concern that the auditor has, that City Council could bring a judicial inquiry where it does not like what the auditor has done. And that is a concerning issue, but that's a policy issue that would have to be dealt with on the facts. It's not an issue before you today. Rather, looking at the issue that you have before you today, it's very clear that the Municipal Act permits the judicial inquiry process to obtain information from any source, including the independent entities that report to City Council. Subject to any questions you may have of me, those are my submissions.
Okay, no, I don't have any questions. Any reply?
I just have a very brief point.
And then I should ask. Yeah.
It's really the issue that I have, and where I think that my position differs from Commission Counsel, is on the whole issue of the law that's come out that deals with the secrecy provisions and the right, that the fact that a civil proceeding is different than a judicial inquiry. And I think that this, I'm not going to repeat the written submissions I've made on this point, but it really turns down on the question of where you think you draw your jurisdiction from. Because in those cases, the government of Ontario, who drafts the legislation, is the one that starts the public inquiry into the process. And this debate in those cases was not on the question of jurisdiction or the right to seek the information, but rather on how broadly that confidentiality provision or secrecy provision in an individual statute applies. In this case, I'm using the secrecy provision as almost a proxy for the jurisdictional issue that I think exists and the conflict that exists, as opposed to just looking at whether or not there are circumstances in which you can look behind that secrecy provision. And because of the fact that you've got, I mean, the provision in there that says that the Office of the City Auditor is not competent or compellable in civil proceedings is there, and it's easily understood. But I don't think the legislature would think that they would have to include a provision that says, well, you, like, if a secrecy provision exists, why would the legislature then turn around and say, well, you have to keep it secret from all other steps that municipal council decides to take, including in the context of a civil or a judicial inquiry? Because it's the same body that's ordering the judicial inquiry versus the city audit, or using the Office of the City Auditor's office, like that, it would be unusual to find a distinction drawn in a piece of legislation. And I don't think that I'm asking for an interpretation of that legislation that goes too far. I think that we just have to be careful in understanding that issue of jurisdiction. And that I think I just don't want that lost in the context of my submissions, and specifically the fact that I don't agree that the fact that there isn't a specific prohibition against disclosure to the entire world, that secrecy provision doesn't protect that information from a subsequent judicial inquiry started. And it kind of goes back to the question, well, what if now, after we finish this judicial inquiry, the city of Hamilton then goes ask the Office of the City Auditor to report on the judicial inquiry? Like, it could end up being a never-ending circle. And I guess I make that point to say, like they're independent processes of each other, and they're independent offices of each other. So I'll just leave it at that.
They're independent offices. I'm not sure
So
that raises a jurisdictional question. I understand that's the way you cast it, but I have difficulty getting beyond perceiving this as a question of how, maybe put it this way, how Section 33 of the Public Inquiries Act and Section 223.22 of the Municipal Act fit together, and whether the two side by side give rise to a conflict or not. And that seems to me to take you back to the question of how do you interpret the operation of the secrecy provision.
right, and I like, you have my submissions on that point. If there's something specifically that you would like me to highlight again, or to try and clarify, because I know that I'd be happy to revisit it. I agree. It always brings us back to how you interpret that secrecy provision, and it does come down to that. And so, I'm violently agreeing with you, I suppose, on that at least.
Mm-hmm. Okay. Thank you very much. We will adjourn. I will get you a decision as quickly as I can.
Mr. Commissioner, just before
Mr. Leonard.
we adjourn, there's just one point I wanted to clarify. As Mr. Levy indicated at the outset, that the city doesn't take a position on this matter. But I do want it noted that we did provide a letter on August the 22nd that just qualified that, and that was on the basis that we had understood in subsequent discussions with council that the scope of the evidence that was intended to be called from Mr. Pellegrini was really narrowed down to the receipt of the Tradewind report. But the point that I just wanted to reiterate, in light of Ms. Lawrence's submissions, that the scope of the evidence that is sought to be called may extend beyond that and relate to any discussions with any city staff. It does engage that qualification that we had advised in our letter on August the 22nd, simply saying that in the event that a decision or a ruling is made that Mr. Pellegrini's evidence could be called, that we would also therefore wish for production of any notes or documents relating to any discussions with city staff in the interest of fairness and consistency. So I just wanted that point to be reiterated in light of the submissions that were made today.
Okay, well then, before we conclude, perhaps we should address whether this is a theoretical or a live issue. Is it possible to get a read on whether, given the specific nature of the testimony which is sought, there are in fact any contemporaneous notes associated with the meetings or interviews?
I can certainly advise you that there are at least one set of contemporaneous notes that I have in my possession, and my voice will grow louder if those notes are sought.
So effectively, yes.
If I may, I did provide the three areas earlier to you about the scope of the potential evidence, and I perhaps too quietly I included a caveat on the last of the three parts, being Mr. Pellegrini's discussions with Mr. Moore on February 4, 2019.
Mm-hmm.
I said earlier, to the extent it may be relevant or some other caveat to to attempt to convey both to both my friends that I anticipate that evidence will not form part of Commission Counsel's examination of Mr. Pellegrini. I, of course, can't speak to what other people may cross-examine him on, but my Commission Counsel's intention is to focus on the interactions regarding the redacted and the unredacted Golder reports and how they made their way to Mr. Pellegrini. And it's my understanding that there are no contemporaneous notes in respect of those two aspects of the evidence that would be relevant or would meet the caveats that Mr. Letterman put in the letter that we provided to you.
Yes, that was my understanding, and that's why I felt the need to express our position in light of Ms. Lawrence's inclusion of the reference to the potential that they would be seeking to call evidence from Mr. Pellegrini in relation to that February 2019 discussion with Mr. Moore, because I had understood that was not the subject of the evidence or the scope of what was being sought as part of this in any event.
Well, I can't comment on that. Your letter is dated the 18th. Commission Counsel's factum is dated the 22nd. So you've had that since the 22nd.
I'm sorry. I think our letter is, sorry, I'm not sure I understood Ms. Lawrence's submission. Is the February 2019 discussion intended to be called from the witness that is being sought from Mr. Pellegrini, or is it not? If it is, then the caveat that we have expressed in our correspondence, I am expressing the view that needs to be reiterated. If, however, it is in relation to only the receipt of a redacted Golder report, in which there are no notes surrounding that, then there is no need for my condition with respect to the position of the city in this respect.
All right, Mr. Ukvi, I take it that you're referring to the fact that there are notes of the meeting between Mr. Pellegrini and Mr. Moore?
Correct.
At the present time, you're not aware of any notes with respect to the other interactions that are contemplated in the factum of the Commission Counsel?
Correct, and I will double check that, and if I have misspoken, then I will advise at least Ms. Lawrence of that fact. And but I don't. It's my understanding there are no contemporaneous notes of that. The stuff that we're talking about here today.
Mm-hmm. Okay, well, we'll stand adjourned, and I will get a decision as quickly as I can. I believe we stand adjourned until 9:30 on Friday morning. Is that correct, Ms. Lawrence?
That's correct.
At which time Mr. Malone will be the witness before the inquiry. Thank you very much. I appreciate the submissions from both counsel. It's very helpful. And as I say, we will now stand adjourned until Friday morning.
Thank you.